Okay, so it is 11:30. So wanted to kick it off today. Welcome everybody who's joining us for this webinar. We felt like we needed to schedule a second one. The last week when we put one of these on, we pretty quickly maxed out our participants. So we wanted to expand our capabilities and make it easier for folks who wanted to access more information about the impact of Governor Inslee's sort of moratorium, eviction, and emergency proclamations on landlord-tenant relationships and responsibilities during this time. So my name is Jason. I'm going to be sort of the benevolent overlord hosting this webinar today. You won't hear much at all from me after this, but let me quickly introduce first Lori Davenport from Tacoma Pro Bono. Lori is the Director of Development at Tacoma Pro Bono. Josh Brumley. Josh is the CEO, the primary partner of the Brumley Law Firm in Kent, Washington. And then Mark Morzal. Mark, am I saying that right?
You are. Yeah, good job.
Nice. Yeah. Names with Z's can get tough, but Mark Morzal. Mark is an attorney at Tacoma Pro Bono who runs, I will say, who runs the Housing Justice Project, whether that's correct or not. And then Mark, you've got a guest in your office with you today as well, right?
Correct. And that's Casey Barton back there. She's also an attorney here at Tacoma Pro Bono and the Housing Justice Project.
That's great. That's awesome. Well, thank you all for coming on board again. This is the third one of these that we've put into place since the emergency proclamation and some orders from the governor that have affected the landlord-tenant responsibilities and relationships during this time. So I will let everybody know, just as an order of events today, if you have any questions, please enter them in the Q&A section. Josh Brumley will be monitoring that and making sure those questions get answered. So please, you can start throwing questions in there right now. They can be as specific or as general as you'd like them to be. But before we get to the Q&A section, we're going to have Josh and Mark sort of review sort of where we're at. It won't be as in depth as our last section because we got a lot of folks who've participated, but we do want to give a sort of an overview of the basics of the governor's updated proclamation, so folks know. So we put everybody on the same page around how that proclamation has affected landlord-tenant relationships and responsibilities during this time. So I'm going to shut up and turn it over to Mark and Josh.
Thanks, Jason. Hello, everyone. So just so everyone's able to follow along on the actual document that we're talking about, it is available on the governor's website. This is proclamation number 20-19.1. It's titled Evictions, and it was issued on April 16th, and it stays in effect currently until June 4th. So again, that's 20-19.1 evictions. And as you look at this document, if you've got it in front of you, or if you need it in front of you, Jason can add the link to the document to the chat when he has a free second here. I definitely encourage following along with the actual document in front of you. There's a lot of legal jargon in this that I think that overwhelms landlords and tenants alike when they're looking at something like this. I can tell you the first 2 pages are sort of, I said this last time and I thought it was relevant. Imagine the first 2 pages as previously on Lost. So you can just throw those ones in the trash. It says, whereas the COVID-19 is bad and there's an emergency and we have the authority to make these orders, blah, blah, blah. None of that is new information to you. So the first 2 pages, I would just skip right over, and we're going to be going from page 3 where it starts with accordingly. And Mark is going to kind of go paragraph by paragraph on the high notes about what this order says in non-legal jargon. And then it looks like we've already got 4 questions in the chat, which is wonderful. And I'll let Mark take it away.
Okay, so my name is Mark Morzal. I'm the managing attorney for the Housing Justice Project. As Josh and Jason mentioned, this particular segment is more a corollary to the previous Lunch and Learn that we did. So if we go over the information too fast and you don't feel that it has the granular detail that you actually need to understand the order, go back and watch that first one, which is on the Tacoma Pro Bono website. So the goal for today is the first thing is we're going to go through the 7 individual sections of the governor's proclamation, the so-called eviction moratorium, but we're going to go through it pretty fast. I should let you know that I'm going to try my hardest to be objective about this. I know I'm an attorney for tenants, but I don't want anybody to think that I'm just giving you the perspective that's most helpful to tenants. There's a lot of areas that are confusing within the eviction moratorium. To me, there was an initial moratorium that entered, I believe it was March 6th, and was effective until April 17th. And then this newest one came out April 16th, so the day before the old one was set to expire. The old one was very cursory. There's a lot of gaps in it. It only talked about 4 things. Notices for non-payment of rent were banned. Notices for termination of tenancy were banned. Court hearings or court orders in order to get eviction orders were, for the most part, banned. And the sheriff was banned from enforcing those types of orders if the court did enter them anyhow. It was there's a lot of gaps and there's a lot of blind spots that were left in this. Now this newest order came out and it built on that and kind of shaded in some of those gaps. The gaps from the previous order were, well, there's a whole universe of different notices that landlords can give tenants that weren't addressed in the first order. Were those still able to be given? Another gap that came up out of the first one didn't talk about late fees or what happens to rent payments. Think that the new one addresses that as well. So there's these issues that came out. But as we're going through those, I think you'll find that the governor's office, everybody who's read this has questions about it. Everybody, every attorney about the application and what it actually means. And I suspect, with no inside information, that when the governor came up with this proclamation and whoever the lawyers were that reviewed it were more concerned with whether what they were writing was capable of being enforced, right? Whether this was something they could actually do rather than honing the language to make it in a way that everybody could get on the same page exactly how it's supposed to happen. So there is questions. I'm going to try to be objective about that and not just give you the tenant perspective, but give you the whole perspective where there's gaps in language, where there's murkiness, where there's muddiness, where there's opacity, where it could be interpreted in possibly in different ways. So we're going to do that. The last thing I should let you know is I have a huge pain in my shoulder. And so it makes it really difficult to sit in this particular location. So I might be switching and moving around the framing on my screen a little bit. I would go see a doctor about it, but the pain is most likely the eviction moratorium that everybody's been talking about for a long period of time. All right, so let's go through the eviction moratorium. There's 7 different sections. They have to do with bans on new notices, bans on eviction orders, bans on law enforcement acting on eviction orders. Also has to do with the ban of rent for lack of access. There's also a section that talks about late fees, and there's a section that talks about payment or what's going to happen to rent increases, a ban on rent increases, and also what I call a soft rent moratorium, which hopefully there's questions about because that one has a lot of difficulty with understanding. So the first one is a ban on new notices. When we were talking about that initial moratorium that came out in early March, it only talked about 14-day and 20-day notices. This new one says that landlords are prohibited from seeking or enforcing or threatening to seek and enforce any notice that terminates a tenancy, right? Or that requires a tenant to vacate. So now for the most part, that whole universe of different types of notices, 10-day notices, 14-day notices, 20-day notices, all those 60-day notices to terminate, all those notices are now out the window because they require a tenant to vacate if they don't comply with the notice. And we know from that first section that that's no longer allowed. One minor carve out that the governor's proclamation does is it does allow landlords to give notices if the tenant's conduct is causing an immediate risk to the health and safety of others. All right, so there's some nuance that happened in there from the first version. The first version had the same carve out, but it also included the tenant or others. This one just says other people.
I'm sorry to interrupt, Mark, but just so everyone's on the same page for the people that maybe joined us a couple minutes after, we have the link in the chat. I'm going to copy and paste that again just really quickly. That link is for the document that we're going over right now, and Mark is on page 3 of 5 in the first bulleted paragraph at the bottom of the page that starts with landlords, property owners, and property managers. So that's what we're talking about specifically. Sorry for interrupting, Mark.
No worries. So there is that carve out for if the tenant's conduct is causing immediate risk of health and safety to others, right? It omits tenants now and just says to others. But it also has some definitions in it as to what conduct actually can be included there, including some big exclusions. And it says that the immediate risk to others cannot be based on the tenant's health or their COVID status, right? So if they have COVID or don't have COVID. You have to state with particularity in your notice some way that the tenant is causing an immediate health risk to other people, but it can't be based on the tenant's health or the tenant's COVID status. All right, so that's the first one. The second one is very similar to what was in the initial proclamation, is that there's a ban on judicial orders issuing writs of restitution, basically, with the same carve out that courts can still issue these if it's based on immediate risk of health and safety, right? So that carve out just transfers down from the first section, transfers down into the second section. The third one is a ban on law enforcement, the sheriff's office enforcing writs of restitution. And that same carve out exists that they can enforce writs of restitution, but only for immediate risk of health and safety to others. All right, so that one's pretty similar from the first proclamation. I don't think there's that many questions on it as far as what's going on. The language isn't that murky. The fourth one we get to has some confusion in it. And it's basically states that no rent or other charges can be assessed or threatened to be assessed when the tenant's access to the property has been prevented because of COVID. The first time I read this, I was like, I don't really even know when this applies. But you could brainstorm some situations that it would apply. And one would be a situation of, a student living in a dorm, right, where they paid for that dormitory. Now the school's shut down and they can't stay in it. That's one of them. Another one would be somebody who maybe they signed a new rental agreement to move into a new place, and now based on COVID, they can't move out of their old place. That's another situation that would apply. But this one's a little bit quirky, and it's not going to have widespread applicability, but there will be some situations that it comes up in. So a landlord cannot charge rent for periods of time where the tenant was denied access based on COVID, all right? So that's basically the fourth section. The fifth section is really interesting because it's a ban on late fees. What's particularly interesting is the wording of this. So it says that landlords, property owners, and property managers cannot assess or threaten to assess late fees for non-payment or late payment of rent if the non-payment of rent or late payment of rent occurred on or after February 29th. So the first thing that jumps out to me about this section is it doesn't mention COVID at all. It doesn't state that the late payment or the non-payment has to be based on COVID. It seems like this is just a flat out statewide ban on late fees from February 29th until retroactive to February 29th, applicable until this order expires on June 4th. But also the language that it uses is really fascinating because it says a landlord cannot threaten, assess, or threaten to assess. So it doesn't really say what happens on June 5th. A landlord could, on June 5th, say, I didn't assess late fees, now I'm assessing them on June 5th. I don't know what the correct answer to that is. Rent wasn't paid this entire period of time for whatever reason, and I didn't assess late fees, but now June 5th, I'm no longer barred from assessing late fees, and there was a running balance this entire period of time. Also, the language that it uses is really fascinating because it says a landlord cannot threaten, assess, or threaten to assess. Correct. And so that was what happens on June 5th. A landlord could, on June 5th, say, I didn't assess late fees, now I'm assessing them on June 5th. I agree. Know what the correct answer to that is.
Jason, what's going on?
Sorry, it sounds like it's Josh or Barker Lori. It sounds like one of you has your Facebook Live on. So if Josh, Lori, or Barker, if you've got your Facebook Live on, please turn that off. Because
it's off. I think it was mine. It's off.
All right, great. Mark, you can continue.
Okay, so it's a good question. Whoever had that question, I didn't catch all of it, so put it in the chat. So my reading on that is not friendly to tenants. I think during that period of time, during the effective period of time of the order, February 29th until June 4th, you can't assess or threaten to assess. But what happens on June 5th? Can you then assess? I think that's a valid position that, if there is a running balance over this period of time, I can and I will make the arguments that it applied to ban late fees over this entire period of time. But I think the other side has just as good of an argument that that language, as weak as it is, assess or threaten to assess, and like we didn't assess it this whole period of time. Now on June 5th, we're assessing it. I don't know exactly what the right answer is. This is one of those sections of the moratorium where the language is just weird. Like I said, I'm not sure who went over this language in advance when they issued it, or what their intent even was here. But one thing is clear. During that period of time, February 29th through June 4th, tenants are safe from getting charged any sort of late fees, assessed any sort of late fees, or threatened to be assessed. But once the period of time expires on June 5th, it seems like then a landlord would be able to assess the late fees, right? And if there's a balance over that period of time, I don't know what the right answer is there. One thing that's going to be helpful in this situation is the exact language in people's rental agreements, right? Because certain charges could only be assessed on certain days, right? I've seen rental agreements where it says on the 5th day of the month, if rent is late, you get a $125 fee, and it only occurs on the 5th day of the month. And so if it happened during the period where you cannot assess or threaten to assess, that charge would probably no longer be valid. Some lease agreements have a $5 running per day balance late fee if you have an existing balance. Possibly that those could be assessed. It's really interesting. I don't have a concrete answer of what's going to happen in this situation. I think landlords have a pretty strong argument for saying on the 5th, I'm going to assess it, and then trying to see which fees are actually going to be retroactively applicable based on the language of the rental agreement. So that's a fascinating situation where the language is murky. And I told you guys up front, everybody, not just guys, everybody up front, that there's situations in this proclamation where the answer isn't clear. But that's another one. And hopefully that question gets back into the feed a little bit. The next one is a ban on rent increases. So this basically says, again, it has the same interesting qualification or lack of qualification where this has nothing to do with COVID. It just says that landlords are prohibited from increasing, threatening to increase rent, increasing or threatening to increase rent, or any deposit amount for any dwelling. And so we know during the period of time, and so a couple things that are interesting. I'd have to look back at the language, but I don't think this includes a retroactive thing like the late payment does, where it goes back to February 29th. So this took effect April 16th, the day of the order, and goes forward until June 4th. We know during that period of time, from the plain language, during that period of time, any rent increase can't happen, right? Nor can it be threatened to happen, which I suspect means giving a notice during this period of time for a rent increase in the future. To me, that would be a threat to increase the rent. And so we know that, but it also doesn't say that there's no qualification that you can't increase rent for units that are affected by COVID. This is for everybody throughout Washington State, and should include all sorts of different dwelling units. So it's interesting in that aspect that from in my position, people during that period of time were absolutely safe, April 16th to June 4th, from having any sort of increase in their rent. An interesting question arises is some people are living on lease agreements where once you go off the lease agreement, your 12-month lease is over, you go to a month-to-month tenancy, and the lease agreement automatically has an escalator in it where the month-to-month rate is a little bit higher than it was when you were on a lease agreement. Again, I don't know the right answer there, but I suspect that that's a rent increase. I mean, it's different than the rent you were paying before, and now you're in the middle of this period where you're covered and the rent goes up, even if it was by the terms of your own express contract. I think those tenants would be safe continuing to pay their old rent amount. But what happens when this expires in June 5th is that rent increases are back on the board. So notices can't be given through that period of time, but afterwards they can. Another interesting question is notices that were given before this proclamation went into effect, right? So theoretically, a notice that was given on April 15th is still a valid notice to increase rent, but we know from April 16th to June 4th, the rent can't actually increase. So when does that rent increase take place? The first month afterwards, July 1st? I don't really know the exact answer, and you're probably not going to find it within the wording of this. It's going to be open for argument on both sides, whether those are going to be valid notices that then just raise once July rolls around, or whether they are no longer valid notices. I don't think that's a very firm position to take. Yeah. So the next one is super interesting again is...
Mark, I'm sorry to interrupt you there, but just so everyone's on the same page, we were on page 4, the bottom section, it's paragraph number 6, sixth bullet. That's the one that discusses threatening to increase the rate of rent for any dwelling or parcel of land occupied as a dwelling. And that also is the first real specific portion about commercial rental property, which if now is a good time to talk about that, I think we kind of breezed over that, but it seems like there's going to be a couple questions about that as well. So would you like to add to that?
Go for it, Josh. You could address that really briefly.
Sure. So that section also says that the prohibition also applies to commercial rental property if the commercial tenant has been materially impacted by COVID-19, whether personally impacted and is unable to work, or if the business itself was not deemed essential pursuant to Proclamation 20-25, or otherwise lost staff or customers due to the COVID-19 outbreak. So the way I read that is literally everyone has been affected by COVID-19. If you have not been able to operate business as normal because there are less clients available to you, customers available to you, if your business was deemed non-essential, so you were forced to close, if you were personally impacted and lost your job, then this could commercially affect you in some other regard as well. So this gives commercial tenants a little bit of an opportunity to use this moratorium as well from increases. This does not affect the other clauses, but this is specific to the increase of rent or the threats to increase rent. So be aware of that for any commercial landlords that are watching or commercial tenants that are watching, that this clause specifically relates to you.
All right, and the seventh section, which I think is the most fascinating section, is what I call the soft rent moratorium. That's not what it's actually called, but that's the way I describe it. So what it states
that's paragraph number 5 on page 4 for everyone.
Okay, so what it states is landlords, property owners, or property managers are prohibited from treating unpaid rent as an enforceable debt that is collectible where such non-payment was a result of the COVID-19 outbreak and occurred on or after February 29th. It also defines what a collectible debt is. A collectible debt means that there can't be any attempts to collect it in person or by a third party like a collection agency. It can't result in the filing of an unlawful detainer, an eviction action. You can't withhold a tenant's security deposit because you'd be collecting it. And you can't report it to credit bureaus, or you can't try to seek it through any other means. What this section basically means is for people who were impacted by COVID and unable to pay their rent, that debt is uncollectible. It's not collectible. Meaning if something's uncollectible, does it exist at all? It doesn't. And from the language of what collectible means, landlords barred from taking any action to try to collect this money back. But there is one major out for landlords in this situation, and that the debt can become collectible if the landlord can show by preponderance of the evidence that the resident was offered and failed to comply with or failed to accept a reasonable payment plan based on the individual circumstances of that particular tenant, taking into account the tenant's financial, health, and other circumstances. So if a landlord, so we know this period for individuals that are not paying their rent based on COVID from February 29th until June 4th, that debt isn't considered collectible, right? It has to become collectible. As a baseline, it's uncollectible. In order to become collectible, then the landlord has to reach out to the tenant, determine their individual circumstance, and offer a reasonable payment plan. Now, this particular section is rife with weird ambiguities and understanding and things like that. One of the questions I get quite frequently, even from tenants that are, landlords, attorneys who are representing tenants, is taking the position, what happens on June 5th with this rent money? My position from the plain language, the only way of interpreting this where it makes sense, given the other provisions that we've gone over, is that this amount of money from February 29th until June 4th, if unpaid based upon COVID reasons, remains an uncollectible debt come June 5th. Some people take the impression that come June 5th, this entire order expires. and therefore it becomes a collectible debt on June 5th, no matter what the landlord does, even if they don't offer a payment plan. I don't think that reading's supported by the language, and I know it doesn't match the intent of the governor. The reason why I say this is the governor has put out tweets afterwards saying, no, it's still unenforceable after this debt, after June 5th, unless the landlord offers a reasonable repayment plan based on the individual circumstance. I'm a little bit baffled that people are taking that position, especially on my side, saying that come June 5th, this all disappears and suddenly the debt becomes enforceable. To me, it results in a real confusion as to what happens on June 5th. On June 5th, the governor's proclamation is not like the message at the beginning of the Mission Impossible movies where it dissolves at a certain period of time if you don't read it, right? It's still a valid order covering a discrete period of time saying this debt is unenforceable. Come June 6th, June 5th, June 6th, this is still a valid order, right? It isn't getting repealed on June 5th. It's still in effect, but it covers a discrete period of time in the past. On top of that, just the way the entire section is structured wouldn't make a whole lot of sense. It wouldn't make any sense at all if on June 5th this disappears. The reason why I say this is because in the middle where you have a section where it describes exactly what collectible means, right? So this isn't collectible for the purposes of starting a unlawful detainer action, an eviction action, unless the landlord offers a payment plan and the tenant fails to do the payment plan. If this all expired on June 4th, it would make no sense because that would mean that the protections for a tenant who just didn't pay their rent under the first section, who can't be given a 14-day notice until June 5th, are even greater than the protections given somebody who's affected by COVID and can't pay their rent, because then the landlord has a way out. They could offer a payment plan and then start an unlawful detainer action. But we know that unlawful detainer action is barred by sections 1 through 3, right? And so you reach these weird dead ends when you start thinking in the way that on June 5th, this is going to expire and it's going to disappear and it's going to dissolve into thin air and suddenly it's no longer a valid order. It's not to say that people on the landlord side don't have arguments as to it. I don't think they're compelling arguments whatsoever. But I've heard from other advocates out and around the state that say, you know, I don't see the language supporting that, but I also don't see where they're coming from, really. I understand the confusion, don't get me wrong, because the language is murky. But yeah, hopefully there'll be some questions about that. But those are the 7 different areas of the proclamation. And so I think we're going to turn it over. Josh, do you have any questions in the queue?
Yeah, it looks like we have 13 in the actual Q&A section. So just for everyone who's typing questions in the chat, we have a specific Q&A button near the chat button. Make sure you're typing your questions into the Q&A so we can keep track of what ones were answered. Otherwise, the links that are going to get posted in the chat that are available to everyone are going to push your question into no man's land. So I think that the first question people had was with regard to the end of a lease agreement. If a lease agreement was scheduled to end May 1st and the lease agreement, the company had offered a month-to-month agreement after that for an increased rate, say the rent was going to go up $500, the tenant did not sign anything saying that they accept those terms, and then this moratorium went into effect prior to the end of the lease. Is the tenant then required to pay that new month-to-month term, or are they able to stay in the tenancy at a month-to-month rate that mimics the terms of their previous lease?
Yeah, so the answer is the second one. They're able to stay in their unit at the rate that mimics the old rate. And the reason, the operation, the way that works is in most contemporary lease agreements in Washington State, once you go off the lease agreement, you become, by virtue of the terms of the lease agreement, a month-to-month tenant. The terms of your month-to-month tenancy are no different than the terms of in your rental agreement, except for the specific period of time that you're allowed to stay there, right? And so if the landlord at that point wants to change terms, then they have to give you a either 30-day notice to change terms or a 60-day notice to increase your rent. But we know from the proclamation that the rent can't be increased during this period of time, right? And so they can't even give the notice or threaten to give the notice to increase the rent. So you're still living on those existing rental amount and the existing terms governing your prior lease agreement. You're just now a month-to-month tenant. On top of that, for tenancies that there's something called a fixed term tenancy. And that's if I sign a lease agreement for 6 months, and by the express terms of the contract, it does not roll over into a month-to-month tenancy. So 6 months and 1 day later, I'm supposed to be out of the place. Well, the ban on new notices specifically says that it applies to expiring tenancies, right? So even that person is covered under the governor's proclamation where they can't get a notice to vacate the unit, even if their fixed term lease ended. So where things would get really hairy, but I think the tenants are still on safe ground, is the situation you did not describe in that fact pattern. What if the tenant were to sign a new lease agreement and voluntarily say, I agree to your new terms, right? I want another 1 year lease, but I'll accept another $200 a month in rent, right? Is that an increase in rent, or is that is it different? Is there a difference there? I think those tenants are still covered, that landlords cannot increase their rent from what the baseline was when this proclamation started. But it's a fascinating question that I don't actually know the answer to, or at least I'm not certain one way or the other whose side would be right on that.
Okay, great. It looks like there is a question with regard to something that I don't think has been covered at all, but is very relevant. There's an individual watching the broadcast that says they own a rental house and was wondering if they can sell it during this time. Are there any restrictions with tenant rights during the pandemic for selling a property that's currently occupied?
That's interesting. So that might be covered by I don't think it is covered by any different proclamation. The problem in that situation is that if you sell, so generally rental agreements are encumbrances that run with the land, right? So if you have a tenant living in a place, you could always sell the place out from underneath them and not terminate the tenancy. The new owner then takes subject to the tenancy, and whatever they want to do with the tenancy is, the new owner's business. But that new owner would be prevented from seeking any sort of eviction until after June 4th or June 5th. So the current owner, in my opinion, would not be in any hot water for selling out from underneath somebody as long as the tenancy continues, the rent terms continue, but that onus would be on the new owner to make sure that those are maintained the same. Otherwise, the new owner would be violating the proclamation. I don't think that I'm aware of, and somebody could correct me in the comments if I'm missing something there. I don't think there's anything in any of the proclamations that prevents selling the home from underneath the tenant if the tenancy continues, if it's not terminated.
Okay. Next question. What recommendations do you have for a landlord about to rent a unit for drafting a lease to protect the landlord given no eviction order from Inslee, or any other practical considerations that a landlord should be aware of for drafting these lease agreements, including the requirement for an increased deposit?
So I'm a little bit confused. Can you read that again?
Yeah, so it has to do with a landlord who's renting to a new tenant, and they're hoping to draft a lease that complies with the governor's order. The way I understand the governor's order, there's no new requirements about how a lease needs to be drafted. Any old lease that you would use would probably be sufficient. Obviously, having an attorney review that is the best way to make sure of that. But if you have a lease agreement that you're worried might not follow these terms, the ones that you should consider are, does it automatically have some sort of rental increase? Does it have some sort of automatic increase of deposit? And if you're entering into a lease right now, this order only goes till June 4th. So unless it was some sort of 1 month term, it doesn't seem that new tenancy would be affected by this order the same way current tenants might be affected from this order. But Mark, if you have anything to add to that.
Yeah, I have one further thing to add. So I don't see a whole lot of problems with entering into new rental agreements during this period of time. There's not a whole lot in the proclamation it talks about. One thing that does jump out in my mind that a landlord would have to be wary of is the prohibition on rent increases also states that there's a prohibition on increasing the amount of security deposits. Right? So you'd have to be very cautious from a landlord perspective that you're charging the same security deposit that you were to people before this COVID thing started, right? Because some landlords may be like, hey, my tenant might come down with COVID, or maybe they're already sick with COVID, aren't going to be able to pay rent. We have to do this payment plan, don't want to do it, too much risk. I'm going to increase the security deposit from $1,500 to $2,000 at the beginning of this tenancy. Seems like that would be in violation of the proclamation. But if you're offering the same security deposit that you were before the proclamation went into effect, it seems like you would be fine under the proclamation. The security deposit thing would be my biggest concern as far as the proclamation goes, but I'm not aware of anything that would really hamper a landlord's efforts from entering into new lease agreements at this point.
Okay, that's sort of how I resolved this in my mind as well. So I'm glad we're on mostly the same page with regard to that. The next question, and it looks like we have maybe 18 questions still to go through in the next 20 minutes. So I'm going to try to go quickly through these and make sure we get everyone's questions answered. It looks like there's some that are repeating. One of the questions, doesn't the RLTA currently limit late fees collectible to $75?
No, so no. So that's a little bit of a confusion. The RLTA does address late fees that are able to be included on a judgment, an eviction judgment. Those are capped at $75. The terms of the rental agreement are generally going to determine what the actual late fee is. So sometimes you'll see somebody come in, get an eviction against them, and a judgment will enter against them, and they owe $500 in late fees under the rental agreement. The most the court can put on a judgment is 75 of those dollars, all right? The rest are still owing, but they cannot be placed on the judgment. And as far as, one issue that I've always come up about is late fees in general, and they're a confusing issue. You can get into appellate level case law and things like that, and there aren't a whole lot of great answers as to what constitute a valid late fee amount and what doesn't. But that's an issue for a different day. The $75 thing for under the RLTA, that only states how much could be included on eviction judgment, not how much a tenant could actually owe in late fees.
Does a landlord have grounds to bring a contract breach action for unpaid rent during the moratorium if the tenant has claimed COVID as an excuse for non-payment?
No. So you'd have to look at the specific language in the moratorium, and hopefully I could find it right here. But it isn't based just on evictions, right? So you can't bring a regular breach of claim contract because that is, and particularly in the case of COVID, because remember we talked about it's an uncollectible debt until the landlord makes it collectible by doing a payment plan, right? So we know off the bat that is not a collectible debt. And when the moratorium described collectible debt, it stated that there can't be any attempts to collect in person. You can't file an unlawful detainer. You can't withhold security deposit. You can't report to credit bureaus. And then there was a catch-all at the end. It said, or by any other means, right? So filing a regular civil action for breach of contract to get a money judgment, normally you could do it without the eviction. I think you'd be fine there. But you can't do it in this situation, especially if the person's claiming COVID is the reason for non-payment, because we know that's still not a collectible debt under the moratorium.
Can the landlord charge a term fee if a tenant purchases a home and they're using COVID as a reason to move out? So this question is kind of confusing because it says, can a landlord charge a term fee for if a tenant purchases a home? Oh, I think that the purchase of the home perhaps is the reason that the tenant is moving out and they're blaming COVID as the reason that they'd like to move out?
Yeah, so I don't know if I have enough facts to answer. I don't know if I have enough facts to answer that question. I think what they're getting at here is somebody breaking a lease term. And oftentimes most modern leases, if you're living under a 6-month lease and you move out in month 3, you are in essence not fulfilling the contract. You're breaking the contract by moving out early. And most modern lease agreements have a penalty that kicks in if somebody doesn't live up to their end of the contract. And I think the question is whether we could still charge that breach of lease fee if somebody breaks their contract early. The question I have about is the COVID reason for moving, right? So people who aren't paying their rent, it says that unpaid rent is an unenforceable, is not collectible where the non-payment was a result of the COVID outbreak. But then again, this isn't a question of like non-payment of rent. It's, I don't know the answer to that, particularly without having more facts to it. And the question left some key facts out there.
Okay, I'm going to move on to the next question. This is one that I think we had a long debate about, Mark, and and I think that a lot of people can
I'm
benefit
sorry, hey,
from this.
can I go back before you do that? So I
Sure.
was looking over really briefly the soft rent moratorium. It says treating any unpaid rent or other charges related to a dwelling unit. So it covers more than just rent. It covers other charges. The breach of the lease would be an other charge, right? If the reason for moving is COVID related, which would make it not collectible unless the landlord gives a payment plan and the tenant fails to do it. Sounds like the landlord could ultimately recoup that money just by offering the payment plan and having the tenant refuse it or fail it. But that's where it stands.
And this actually touches on a couple different questions, and that is a great segue into the one that I was just going to discuss. Is we need to discuss the reasonable repayment plan. So I think that there was someone in the chat, there's a handful of questions that look like sound legal practice, said, what are we considering evidence that the tenant was offered a repayment program? Tenant was sent USPS and certified, and the repayment offer was refused to respond. The tenant refused to respond to any repayment offer. Is that evidence that the landlord produced a reasonable repayment plan? And I guess my response to that question is that doesn't discuss whether or not that repayment plan is reasonable. That's just proof that a repayment plan was offered. The reasonableness needs to be decided based on a totality of the facts. So what was the tenant paying in rent? What was the offer for the new rent amount? What are the facts about the tenancy that affected the ability to pay? So in our last Zoom meeting, we talked about, do landlords have the ability to require bank statements from their tenants when offering these repayment plans to show that COVID was the reason for their inability to pay? And I think, Mark, you went into a little bit of detail on that, and I'd like you to do that again here to say, no, they can't do that. Or your position is they couldn't require bank statements as a showing of COVID affecting their tenancy.
So I agree with your response to the initial question, that the issue that's going to come up is whether the payment plan was reasonable when it was proposed. But I kind of take the landlord's position on this one a little bit more, where I think it, regardless of the payment plan, as long as it wasn't oppressive or onerous, is probably going to, the tenant never responded, right? What's a landlord supposed to do in that situation when a tenant is simply failing to give the necessary cooperation for a landlord to be able to come up with reasonable terms? I think the landlord in that situation has a pretty good argument to go forward with the eviction once, of course, the evictions are being heard again and the moratorium lifts and everything like that. But as far as the proclamation, I feel bad for landlords because it really left you hanging in this situation as to what's reasonable and what isn't reasonable. Basically put the entire burden on the landlord to reach out to the tenant, to gather information from the tenant and come up with an offer that is reasonable. And I have no doubt in my line of work that we're going to see plenty of arguments in front of the court when it comes time for unlawful detainer hearings, where one side saying that wasn't reasonable, the other side saying it was reasonable. And it's going to have to come down to the commissioner or the judge that's hearing it to make a determination whether it was or wasn't. There's no guidance in the proclamation as to what constitutes reasonable. I mean, reasonableness in any ordinary legal standard is just an objective standard, right? Looking at all the facts of the situation, what would a normal person consider to be reasonable in that situation? Or an ordinary person, I should say. And so that, there's not a whole lot of guidance as to what it is. We do know that it does have to be individualized to a particular tenant. So if you're running an apartment complex with 30 different units, you can't mail everybody out a letter saying, I understand COVID hit everybody, but your rent's going to be an extra $250 a month starting July in order to make up with this amount that was previously missing. That's not individualized or particularized in any sense of the word, right? You actually have to make proactive efforts to reach out to each tenant and determine what they're actually able to pay and whether that payment plan is reasonable given their health and financial circumstance. Landlords got put in a tough boat on this one. I have yet to see, now I don't work on the landlord side, so I don't keep up with this stuff, but I've yet to see somebody come up with maybe there's somebody out there that came up with a generic letter saying, please respond to this. We need to know what your financial situation is and things like that. If a tenant doesn't respond to that, I think the tenant's putting themselves in the stew, right? They're putting themselves in the hot water, because if the landlord's making efforts to reach out and they could show through certified mailing and things like that that the tenant received it and was just blithe and ignored it, I would be tempted to think those are cases that are going to go forward with valid evictions. The harder situation is going to be when somebody responds and says, yeah, I have this much money that I could pay, but it's way less than what you want. I think landlords are going to be stuck just eating a lot of those situations because people have other things that they need to pay, right? Rent isn't the only thing that's on their plate more often than not. And people who are getting, who are unemployed because of COVID, interesting question is, what if somebody isn't working, period, because of COVID? Your income is zero. What's a reasonable payment plan then? I don't know, but if you have $0 coming in, it seems like that payment plan offer is going to have to wait until there's some income coming in. The proclamation is not really clear on this, and it's going to be some real factual hurdles that come up when eviction hearings come up again.
Now, there was an issue with the uncollectible nature. So if you're a landlord and you're proposing anything, you're doing more than you have to, right? But this protects the tenant if you do nothing. And that's why I think a lot of landlords are feeling frustrated by these orders, is they seem to be more on the side of the tenants. But my position throughout this process has been, if you're a landlord, forcing someone who doesn't have a job to pay your mortgage to make sure that you don't lose this property, you don't go into foreclosure, or whatever that need is that's driving you to collect from some person, is maybe not the best way to resolve everybody's issues, right? So if a tenant isn't working, they don't have the ability to pay, and your ability to pay your mortgage is limited. You should be talking to your lender in those situations and trying to get some sort of payment plan worked out with your mortgage holder. There's plenty of understanding lenders out there, and if you're not taking that action and you're trying to force your tenants to pay when they don't have money, the Attorney General's office can get involved and criminal charges can be filed. And we are aware at our last Zoom meeting of a group of private attorneys who have organized in support of the Attorney General to enforce this order against landlords as volunteers. So if you're a landlord and you're threatening eviction, or you're threatening rent increase, not even actually evicting or actually increasing rent, but the threats themselves to do those things are a violation of this order. So our position has always been, have a communication with your tenants, have a communication with your landlord. The Center for Dialogue and Resolution is a mediation center in Tacoma. I'm going to have Jason put their link in the chat. They do sliding scale mediations and settlement conferences, lots of different options for people in hard situations that want to avoid the court process. Eviction in and of itself, if that's the route that you end up going, isn't going to be available very soon. The courts are going to be inundated with stuff that they have to deal with criminal trials that have been put on hold. There's a lot of things that are happening now to try to prevent that backlog from being a bigger issue, but there's no way around it, that when the courts reopen, they're going to be inundated with bigger fish to fry, if you understand my drift here. So having a conversation through the Center for Dialogue, or an informal situation where you just pick up the phone and talk to your landlord, or pick up the phone and talk to your tenant and say, listen, we're all in this together. You didn't create COVID. I didn't create COVID. We're all under the governor's order to not be at work or to be affected by work closures. How can we meet everyone's needs together? And that's what I really want to harp on in this Zoom meeting, is everyone is upset about their landlord is forcing them to do this, or their tenant is refusing to do that. But there's definitely a way to meet in the middle and have these communications in a way that everyone wins. And I really think that that's possible, but you have to be willing to have those communications. And sometimes your tenant or your landlord isn't, and potentially reaching out to the Center for Dialogue, which is centerforresolution.org, they can get involved and help mediate those hard conversations when you need someone in the middle.
So can I add one thing really fast? So you mentioned landlords are landlords that have mortgages, and there's no doubt those are hard times too if they don't have rent coming in. For those of you in that situation out there, go back and watch our previous video or previous Lunch and Learn. Casey Burton talked really briefly about some relief that's available under the Federal CARES Act. That's the Coronavirus Relief and Economic Stimulus Act, as far as deferring payments or being able to reduce payments for periods of time. I believe that's going to last until the end of the coronavirus emergency, which might be soon, considering the way we're going around the United States, or until December 31st, whichever happens first. But it's in the first 5 minutes of that previous Lunch and Learn, and Casey had some great information for people in that situation. Oh, and let me add one last thing. So you mentioned that landlords would be frustrated by this, proclamation, this series of events. I agree, and I could share that frustration. I could appreciate, not share because I'm not a landlord, but I could appreciate that frustration. But at this point, the proclamation is there. It's water under the bridge. I think the best way to go forward is to accept it for what it is and start finding out ways to work around it, or to actually comply with it, which a lot of these questions did have to do with. So I think that's great that landlords are actually trying to understand how they're supposed to do this thing. And I'm sorry that some of this doesn't have the best answers because the proclamation's pretty blank. We could argue the policy aspects of it until we're blue in the face, but it doesn't matter because it's out there now. If you disagree with the policy of it, I get that's why we have elections. Some people, won't like the Inslee because he did this. Others are going to be fans of his for doing this. But a tough policy decision had to be made, and they put a lot of the onus on property owners rather than those who lost jobs because of COVID.
Now we have 14 more questions and 9 minutes left, so I'm going to try to hammer through these. What happens when a tenant was employed by the landlord and got a rent discount? I have a situation where a tenant was fired after COVID and therefore his rent was raised due to the lack of the discount. That is a very specific and very confusing situation to be in. And I'm not sure. I don't think that the landlord could raise the rent. That's my position.
Yeah, so that is very factually specific, and reach out to somebody, whether it's myself or Casey, to talk about that specific situation. But we know that rent increases are banned, right? So they're prohibited. You can't increase the rent. And we talked about the situation where if the contract automatically increases the rent, I think that's still covered as a rent increase, and you can't do that during this period of time. The other question is, so you can also provide, we know from Section 1 of the proclamation that you can't give notices based on non-payment of rent either during this period of time until June 4th. It's a tough situation to be a landlord who had to fire somebody, an employee who also had a rental agreement. You also have the question of whether that's even covered by the RLTA. So generally the RLTA excludes cases where somebody is an employee of another person if it's based on an employment contract. And so you might not even be in the RLTA, but you're still covered by the proclamation. So there's a lot of more to unpackage in that particular situation beyond than, just the facts that we know.
Next question is from Maley. It looks like, what if new residential tenants signed the lease to move into a place on June 1, but the previous tenants cannot move out due to the builders not finishing their new home due to COVID? Can the landlord still collect the rent from the new tenant per the lease, even though the old tenants or the new tenants can't move in?
No. So your burden on rent is going to be from those old tenants, right? You can't charge, under the proclamation, you can't charge tenants for places where their access was denied because of COVID. Now, in this situation, it seems like the access was denied in a tertiary sense. So the people wanted to move in, but the previous owners couldn't move out because of COVID. That still seems to follow the proclamation there, where you can't charge those new tenants the rent for a place that they can't stay at. They're never in possession of it in the first place. I think even without the proclamation, you probably couldn't do that. But for sure, under the proclamation, you wouldn't be able to do that. Yeah, and so the question is, the issue really is the people that are living there now who are occupying the premises, who can't move, those are the people who you need to be trying to collect the rent from. And if they can't move based on COVID reasons, COVID-related reasons, again, is that collectible debt? Doesn't sound like it until you offer a payment plan. So, that's a tricky one right there. But I think that the answer is solid as far as what you're supposed to do.
The follow-up question was, does the landlord just terminate the lease and request the new tenant sign a new lease? I think that would be the best option. We kind of are all rolling with the punches here, and we don't know when your house is going to get finished and the tenant is going to be able to move out. So until you have a date specific about that, I think that the landlord shouldn't even try to enter into a new lease agreement with the the new tenant. The landlord should just work with the current tenant on what a repayment plan could be for the current tenancy amount. Is that how you
So then you might reach more hot water in an unrelated sense, is that that tenant that's waiting to move in, it sounds like they already signed a rental agreement for it. If you decide not to honor that rental agreement when this moratorium lifts, are you now breaching that previous agreement, right? And are you able to do so? Does that previous agreement have some sort of force majeure clause or something that terminates? Is there impossibility or something like that, a contractual defense that allows you to get out of that that contract with a new tenant, right? So, if you sign a new lease agreement with the existing tenant, you might be breaching the new agreement that you signed with the previous tenant who can't move in at this particular point in time. So there's more questions there too. That's some thin ice there that they're skating pretty fast on.
I think we might have answered this one, but I'm going to read it real quick. On reasonable repayment plan, if a tenant does not share any details about whether non-payment is due to COVID, is that considered reasonable? Should landlord offer a reasonable payment plan even if there's no response from tenant?
Wow, that's interesting. So I don't know that the proclamation actually states. So the defense arises, right, or the non-collectible debt arises when the payments are a result of the COVID-19 outbreak, not when the landlord learns about it. And so that's a novel one. That's the first time I've heard that one. But it seems like landlords need to tread very lightly in that situation, because what happens if they do this eviction, the moratorium lifts, they try to evict this tenant, and the tenant shows up and says, hey, look, this was all based on COVID all along. The only leg that the landlord's going to have to stand on is like, look, I reached out to them and they never mentioned anything to me. How am I supposed to be held responsible for that at this point? Maybe that's a good argument for the landlord. I suspect it probably is. I mean, if I was doing landlord work, I'd be able to make it work. But, I don't. I do tenant side. So I think if there's an unresponsive tenant that you have no idea what the non-payment is, and you could show valid, reasonable efforts to reach out to them, you might be safe moving forward with the eviction no matter what they show up in court, but that's not for certain.
And I'm going to try to hammer through these last ones, Mark. If a tenant simply stops paying rent during this period, what are a landlord's options?
Well, the first one, again, this goes back to the reason for the non-payment. If the non-payment is just non-payment and there's no COVID-related reason, you can't give a notice until June 5th. But you'd be perfectly fine giving that notice on June 5th of a 14-day pay or vacate and moving forward with the eviction process at that point. You are in that situation, the landlord's just in a waiting game because they can't give that notice ahead of time. If the non-payment's based on COVID, then you're stuck with this uncollectible debt thing where you have to offer the payment plan, right? So it depends really on whether this is COVID related or not. If it's not COVID related, start on June 5th with the eviction with a 14-day notice to pay rent or vacate. If it is COVID related, the first time the tenant's going to be on the hook for rent is going to be July 1st, absent any sort of payment plan, reasonable payment plan being offered to the tenant to come up with this money.
Just a reminder, if you guys want a video link emailed to you, please put your email into the chat. Jason will make sure that you get that emailed to you. There's also the previous video that covered different questions and some other topics, including this one. There's a question about if a 14-day notice was served on 2/13/2020 and thus as of 2/28/2020 could have started an unlawful detainer action, but the UD action was not started and then the proclamation went into effect.
Yeah, so interesting question. Really good question, actually. So theoretically, it also depends on some other factors, whether a summons and complaint was served and things like that. There's something in the RLTA that basically states that notices go stale after 60 days. So if you wait 60 days after giving a notice, that notice is stale, you have to give a new notice. It's unclear how the proclamation works into that, whether the proclamation is more a tolling of that period of time or whether it counts towards that period of time. You may have to give a new notice, but theoretically, let's just go baseline. The notice was validly served at a time before the proclamation. Once the proclamation lifts, you could serve that tenant with a summons and complaint and go forward with the eviction. But you do have to wait until June 5th.
Right, and I think that this one talks about waiting for June 5th as well, but it has a little bit of a different issue we haven't covered. Month-to-month renters given notice mid-February for end of rental agreement March 31. Have text showing pushback on this prior to COVID. we are selling the property. They're still in the home. They've refused the property owners access to property and threatened them if they came onto the property. They have not paid rent in 2 months. Can we start the eviction process prior to June 5th, or do we need to wait for June?
Most likely June 5th. But you know, you hate to hear about situations like this, landlords going through that. And, you know, I don't know if the allegations are true or not. It's awful if it is true. But you might want to pursue other options as well, right? If there's being threats and things like that, it's entirely possible you talk to somebody about some sort of protection order or something like that. I don't know if that's going to be the right avenue, but it sounds like you're going to be stuck waiting until after the moratorium lifts in order to get those individuals out.
Well, and just briefly on that, I think that there's the discussion about health and public safety as a method to still enforce evictions. And then we had heard and discussed at our last Zoom meeting that the option that other attorneys have completed the eviction processes that were started pre this eviction proclamation. And then when they gave those to the sheriffs or to the enforcement arm of the police, that they were not, the police just simply wouldn't enforce them.
So there is that carve out for health and safety. You have to show a significant and immediate risk to the health and safety of others caused by the resident. So given the facts that we had, I mean, possible that that those facts rise to that level, but the court's being very scrutinizing of this. And like Josh just mentioned, we had, you know, I've spoken to attorneys personally who are able to navigate that process and get rid of restitution based on health and safety, only to have the sheriff's office say, we're not enforcing it right now, sorry. You know, and then they'll be able to enforce it come June 5th. So the question is whether you want to roll the dice. This particular landlord wants to roll the dice, try to navigate that process of health and safety if the facts warrant it, and get their writ. But there's no guarantee the sheriff's going to enforce it, and they might have to wait until June 5th anyhow.
Would the repayment plan only pertain to rent that wasn't paid from 2/29 to 6/4?
Yes.
What stops a landlord from starting an eviction because of not paying accrued late fees starting June 5th if the landlord decides to impose them?
Wait, read that again.
What, I think you covered this, but what stops the landlord from starting an eviction because of not paying the accrued late fees starting June 5th?
Well, the first thing that stops you is not the proclamation, it's the Residential Landlord Tenant Act. So you can't base somebody's occupancy on in a place just based upon late fees. It has to be non-payment of rent. So that person has a bigger fish to fry in the fact that even when the proclamation lifts, you can't evict somebody just for owing late fees.
If the tenant doesn't pay rent, can a landlord ask, and is a tenant expected to inform the landlord about being laid off and unemployment payments or other income like stimulus check in order to negotiate for the purposes of reasonable?
Yeah, so we covered that, you know, in a previous answer a little bit in the fact, and I'm going to repeat the answer, that the proclamation isn't very clear about what amount of information sharing has to happen between the sides. And Josh, you gave that big soliloquy about landlords and tenants working with each other in this particular period of time. The landlord for sure, though, has to make some sort of inquiry. It seems like that from the proclamation. They have to make the efforts, but if a tenant is being unresponsive, I suspect those evictions will probably go through because the court's going to find that it's unreasonable for the landlord to do anything more. But if it's just haggling over the amount of money, now you're in really shaky ground. But a tenant who's just completely unresponsive, eventually you're going to be able to move forward with the eviction process by saying that they refused a reasonable payment plan.
What happens if the tenant and landlord can't agree on a payment plan?
Yeah, so you have two options. Keep on working on it, or you mentioned the Center for Dispute Resolution might be a viable option at that point. The other one would be to, once you get certain to the point that, look, this is reasonable and they're refusing it, you could try to roll your dice in the courtroom and, you know, have your attorney argue this was as reasonable as could possibly be expected. If the court agrees with you, they'll go forward with the eviction. If they don't agree with you, then, you know, they won't. It's hard. It's going to be a factual situation before the courts, whether something was reasonable or not.
If the tenant is month to month and I sold the property, would the tenancy still need to carry over with the new owner, or would the tenancy end at the end of the month?
No, it's still an encumbrance that runs with the land. It's still a month-to-month tenancy for the new owner that needs to deal with it. That's the way it worked before the proclamation. It's the way it worked now. The proclamation, to my knowledge, has not changed that one bit.
Are there any steps you can take for people who are violating the terms of their rental agreement not related to unpaid rent, since you can't serve a 10-day notice to comply? And I think
Not really.
there's,
Not really.
unless it's a health and safety issue. In our last Zoom meeting, people said, well, what if I'm scared because I'm a landlord and I live next door to someone who's contracted COVID? Can that be a health and safety issue? No.
So yeah, so we know COVID can't be used as a health and safety issue. The only way you could give a 10-day notice at this particular point in time is if you could show a significant and immediate risk to health and safety. 10-day notice for having an unauthorized pet, you can't do that because that's a notice that requires them to vacate if they don't comply with it, and that's barred by the first section of the proclamation. Essentially, the governor doesn't want people getting evicted and being out in public, you know, looking for housing and not social distancing and whatever.
Last question, and then we'll see if Lori has anything to add about the other clinics and services that that are offered. Oh, Jason clicked that it was answered already.
Jason makes an appearance.
Jason, can you read that? Yeah, thanks, Jason, for moving so quickly on that one. I didn't read it yet. So, Jason, why don't you read that one if you can find it?
All right, I'm gonna find it for you real quick here.
Why don't we, while we're looking for that, Lori, do you have anything that you'd like to add about Tacoma Pro Bono or the organization that you're executive director of?
Sure. The first thing is we want to plug our next public Zoom Lunch and Learn, which is going to be May 12th, Tuesday, 11:30 to 12:30. We're going to be talking about family law. Thanks to Josh and his office. We'll be here. We'll have a representative of the Family Justice Center to talk about domestic violence protection orders. And I understand that there's going to be some changes in how those are going to be happening. So you'll want to tune in. And for new clients who want to reach us, just go to our homepage, click on the little thing that says leave your contact information with us, and we will get back to you. Everything's online now.
Mark, it looks like Casey might have something to say there.
No, I just wanted her to get some screen time.
Okay. Casey, thanks for joining us. You added a lot at the last meeting. There's a dog there, it looks like. Jason, have you found the question?
I did. I found the last question. Sorry about that, Josh. I was quick on the trigger. So, can a landlord keep the monthly amount due the same, but change the other terms such as assessment of late or other fees?
So the assessment of fees is where things get tricky, right? Because we know that they can't increase rent or other charges, right? Or late fees or other charges, rent or other charges. So that's where it gets tricky. But as far as changing other terms of the rental agreement, that the proclamation doesn't cover. So if you want to change it from, you know, your parking spot is spot number 5 to spot number 6, you can still give a 30-day notice to change the terms of a tenancy, assuming they're a month-to-month tenant. They're under a lease agreement. The terms are fixed during the period of the lease agreement. So you can't do it if somebody's in the middle of a 12-month lease. But for a month-to-month tenant, you could change the terms of the rental agreement with a 30-day notice. You'd be barred from increasing the rent or other charges right now, but you can still change the other terms.
Great. Thanks, Mark. And then I think we're wrapping up here. So I'll give final words for Josh and Mark, Lori, and Casey. But just a final reminder to the folks that are still on the call, if you would like a copy of this recording, any of the links that we mentioned during this webinar, and a link to last week's webinar as well, please put your email in the chat, and so we'll get that off to you by sometime today or tomorrow. So Josh, Mark.
Yeah, just so everyone else is aware, I'm sorry for just jumping in. I've got another meeting that's starting without me in the other room. Friday, there's also an SBA business loan webinar that I'm hosting with Austin Patchins of Heritage Bank. It should be very informative. You can ask questions about the options that landlords or other small business owners have for aid from the SBA and the programs that are available, and have your questions answered live. That's this Friday, and I'll have Jason send the link out to that to everyone as well, with the family law link, which will go into detail about parenting plans and other things, domestic violence protection orders, and other relevant issues during COVID. So thank you all for attending. I'm gonna head out, but goodbye.
Mark, Lori, Casey, any final words?
No, good question.
Oh, no, the questions are great. Thank you. Thanks,
Great
everybody.
Yeah, thanks everybody for attending today. I said, we'll stay open for a few more minutes so people can put their emails in the chat. But thanks, Lori. Thanks, Mark. Thanks, Casey. And thanks, Josh, who's now gone, for spending an hour with us today to give us an update on landlord tenant laws and responsibilities during this emergency time. So thank you all so much. We appreciate it.
Thanks, Jason.
All right. Thank you, Jason.